Every day in the USA, people find themselves in court.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Dimitri Ray Woods, case number 2024 CR 160. Mr. Woods appears by Zoom, as does his counsel, James Watts. Brett Sweeney appears for the state of Kansas. Pursuant to docket notes from November the 26th, the parties had agreed to try this case on stipulated facts today, with the defendant desiring to preserve his double jeopardy claim for appeal. Counsel, if you would review with me exactly what the parties' agreement is regarding the various charges which originally existed in this case.
Yes, Your Honor.
Judge, my understanding was simply a trial on stipulated facts on what would now be count.
Your Honor, it's on count 4 of the amended information that was filed on September 5th following the preliminary hearing.
Judge, my understanding is there's no further agreement regarding sentencing, simply a trial on stipulated facts on the sole count
Of aggravated battery against a law enforcement officer.
Actually, I think it's
Your Honor, it's the level 5 and the amended information on count 4.
All right. So battery against a law enforcement officer, a level 5 felony, correct?
Yes, sir.
And the disposition of the other charges which existed in the case?
Your Honor, those are being dismissed per agreements for the stipulated facts on count 4.
All right. Thank you, Mr. Sweeney. I appreciate that clarification. All right. Mr. Woods?
Yes, sir.
Okay, I've just got some things I need to go over with you. Now, the last time we were in court, the court recalls that it specifically went over your right to a jury trial in the case and you waived it. Is that still your position, that you're waiving a jury trial in this case?
Yes, sir.
And Mr. Woods, implicit in what we're doing today would also be a waiver of your right to be personally present at the trial of the merits of your case. Are you also waiving your right to personal presence?
Yes.
All right. And further, the court does want to note for the record that this court had earlier entered a ruling in this case regarding a motion to dismiss that was filed by Mr. Woods. He essentially renewed that by a motion to dismiss pursuant to KSA 6212 filed on November the 14th, which essentially raises the same double jeopardy argument that was dealt with in the court's original ruling. The court, for the record, notes that it has considered the motion to dismiss pursuant to KSA 6212 and denies that motion. The court will grant no relief, finding that essentially its ruling would be the same as it was that was earlier issued in writing regarding the original motion. What happened to Mr. Watts?
Judge, he just cut out. We just may give him a second to get back on.
I blinked off, Your Honor, and I don't know why.
I hope you can stay with us, Mr. Watts.
As do I.
All right. Not knowing exactly where you fell off the meeting, Mr. Watts, I will repeat that this court has found that Mr. Woods has knowingly, and here on the record today, waived his right to a jury trial, waived his right to personal presence at his trial on the merits. And furthermore, the court has ruled today that the motion to dismiss pursuant to KSA 6212, the redo of his original motion, is once again denied by the court for the same reasons that were expressed in the original ruling, which Mr. Watts, interestingly, you called a letter ruling. I'm not sure why you called it that. I don't recall that it was in letter form, but there is a written ruling of record denying the original motion to dismiss, which the court again reiterates here today. Proceeding further then with the trial on stipulated facts, the court is aware of a document submitted by the defense this morning to the court. It is entitled Stipulated Facts. It is 2 pages in length. I trust that that's the document we're going to be discussing here today. Mr. Watts?
Yes, sir.
All right, Mr. Watts, from the defense standpoint, are there any additions or modifications to the stipulated facts?
None that I'm aware of, Your Honor. The first paragraph of the stipulated facts contain what we believe are the appropriate stipulated facts for the count. The following paragraphs simply talk about the motion to dismiss, as Your Honor has previously noted.
All right, thank you, Mr. Watts. Does the state have any additions or modifications that it wishes to make regarding the statement of stipulated facts submitted by the defense?
Your Honor, no additions or modifications. They are stipulated and agreed upon.
Very well. Court will read those into the record. Court finds that the facts that would be proven in this case would be as follows. On or about December 5, 2020, at the El Dorado Correctional Facility, located within the boundaries of Butler County, Kansas, the defendant, Demetri Woods, made physical contact with Sarah Owens, at the time a properly identified corrections officer, in performance of her duties in a rude, insulting, or angry manner. Mr. Woods was at the time of the incident an inmate at El Dorado Correctional Facility and was at the time responding to an incident involving another inmate when Ms. Owens was struck. What the court has read is the entirety of the stipulated facts in paragraph 1 of the document. As Mr. Watts appropriately noted, paragraphs 2, 3, and 4 essentially involve case procedural history and are not part of the stipulated facts record in the case. This court does find that the stipulated facts in this case is the entirety of what the court is to consider regarding evidence to prove guilt or innocence in this case. The court does find that most of the elements of the crime have been covered by the statement of stipulated facts, but the court must find, based on the stipulation which both parties have agreed to, that an essential element of the offense has not been proven by this stipulation. And the court has 2 statutory citations for that proposition. Battery under KSA 215413 requires that to be a battery, there has to be, the defendant has to knowingly cause physical contact with another person when done in a rude, insulting, or angry manner. Furthermore, KSA 215202, culpable mental state, requires, and I'll read as follows, except as otherwise provided, a culpable mental state is an essential element of every crime defined by this code. A culpable mental state may be established by proof that the conduct of the accused person was committed intentionally, knowingly, or recklessly. The court notes that the legislature specifically required that for a conviction to take place for battery, and then implicitly any form of aggravated battery, the state must show that this was knowing conduct, that it wasn't done potentially accidentally. It was done knowingly in a rude, insulting, or angry manner. And the court cannot infer that just because the touching was rude, insulting, or angry, that it was also knowing, because these are separate, independent requirements of the statute. The court had previously inquired if the state had any modifications or additions to the stipulation. They said they didn't. Court must again make the decision in this case based solely on the stipulated facts currently before the court. Mr. Woods, I don't know if you've understood anything that the court has said to this point, but the court at this time has no choice here but to enter a judgment of acquittal. In other words, that's not guilty finding in regards to count 1, because the stipulated facts simply do not constitute the full elements of the crime in this case. I know that wasn't the intended result here, and I detect no bad faith on behalf of the defense. I'm always puzzled when the prosecutor lets the defense attorney draft the stipulated facts regarding elements that the state is required to prove. And again, I'm not again suggesting that Mr. Watts has done anything but put forth a good faith stipulation of facts with the idea that this case would ultimately be decided on appeal rather than at the trial court level. Ironically, Mr. Woods, it would appear that since the state has dismissed all of the other charges that were brought in this information, that they've had the full opportunity to prosecute those charges. They dismissed the others and went to trial on a single count, which the court has entered a judgment of acquittal. So ironically, Mr. Woods, for different reasons, I believe that concepts of double jeopardy prevent the state from further prosecuting any of the other charges in the case.
Your Honor, if I may,
You may.
it was my contemplation that those charges would be dismissed upon a successful taking of a plea.
That's not what you stated earlier, counsel. Well, actually, there was no plea.
Well,
And-
right. I
and the
mean,
court very much understands that, Mr. Sweeney. That's a common understanding that it's dismissal upon successful taking of a plea, but there was no plea here.
right. And if I may, Your Honor, I mean, I know that it's pretty rare that we do trial on stipulated facts, and maybe I should have, maybe I just worded that incorrectly, but I guess it was my understanding that those charges would be dismissed upon a successful finding of guilty per the stipulated facts within what had been presented to the court.
If
I'll
you have
check
a
with
written
that.
record of that agreement between you and defense counsel, I will consider it. Actually, these courts' comments are merely that. I haven't been asked to rule it specifically regarding any double jeopardy claim in regards to the other counts. But only made a ruling and entered judgment of acquittal as to the sole count. I believe that was count 4 that was submitted to the court for the trial on stipulated facts today. What the legal implications are, the status of the rest of the charges, I suppose we'll leave up in the air. Court's already given what it thinks based on what's been announced in court, very well may be the result. But Mr. Woods, I don't have any reason at this point to set any more court dates or to have you answer any further on this. You may hear something further regarding this in the future. I think it was the intent of the parties that today's trial would essentially end district court proceedings. And the case would go up on appeal on the issue that you had raised in your motion regarding double jeopardy. But essentially, you've been acquitted by the court. Mr. Woods, I've just got one other thing that I want to say, whatever it's worth. A lot of times, prison inmates have the belief that the court system is never fair with them, that fair and unjust things and just things don't happen in court. Maybe you would look at things differently based on today's case. I believe you have the right to be treated fairly and in accord with the law, and I made my ruling in that regard. Mr. Woods, anything you want to say? Okay. That's fine.
I'm sorry about the incident. I appreciate you.
Okay. We'll see what happens from here.
Thank you.
All right, counsel, I don't believe there's any further business we need to take up at this time. If there's nothing further, the Demetri Ray Woods matter is in recess. This meeting may be ended for all at this time.